Written constitutions have this particular feature. They express the ways in which they can be changed. You see, in places with unwritten constitutions, Parliament can alter the constitution and make new legislation, new constitutional law, very easily. And sometimes it's actually hard to know which ones are normal, ordinary legislation and which ones are constitutional laws. But this does not happen with written constitutions. Written constitutions usually express the way in which they are to be changed. So, how can we change the Australian Constitution? That's what we're about to see today. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will analyze section 128 of the Australian Constitution. We're going to discuss how to alter the Constitution of the Federal Commonwealth. If you're not subscribed yet, now is the time to do it. By doing that, you're not gonna miss any of our videos and you'll be notified. You will know every time I put new content on our channel. Okay, before opening the Constitution in section 128, I would like just to say that we can find a lot of reasons for changing the Constitution. Sometimes mistakes ought to be corrected. Sometimes certain parts of the Constitution lose their efficacy, and sometimes the times change. Society changes, so we have to update the Constitution to keep up with those social changes. But when we look at these rigid constitutions, like the Australian Constitution, we also notice that this willing to change comes with a willing to preserve certain values and certain institutions that were originally established. So at the same time we want to alter the Constitution and update it, but we also want to preserve the institutions and the values of society that were entrenched in the Constitution. You see, since constitutions are relevant guides for society at large, we don't want them to keep on changing all the time. For the sake of social continuity, we need to have some conservative elements there. That is why what we call rigid constitutions, they lay out certain procedures, certain processes that have to be obeyed in order for the constitution to be changed. Rigid constitutions will lay out the way in which they are to be formally altered. Hey, did you notice that I used the word formally? That's because there are certain changes to the constitution that do not alter the text of the constitution. The form still remains. So yeah, we can alter the constitution without formally changing the constitution as well. It's what we call informal constitutional change. And it usually happens through constitutional interpretation by the highest court or the constitutional court in the land. In Australia, for example, the meaning and the content of certain constitutional provisions have changed without changing the text of the constitution itself, just by a different approach to different methodologies implemented by the High Court to interpret the Australian Constitution. So in this sense, we can even say that the Constitution of Australia has changed a lot, because the High Court has changed certain provisions of the Constitution informally. But as we are about to see, the Constitution has also changed formally, and this is the topic of the video today. Now is the time to open the Australian Constitution. Let's take a look at section 128 to see the process according to which we can change the Constitution formally. Okay, section 128 is quite big, so here's what I'm going to do. I'm going to read step by step, and then I will explain each of these parts of the provisions as we go. So let's start. Section 128, Modes of Altering the Constitution. Well, from this outset, I just wanted to highlight that to change the Constitution, to alter the Constitution, we can not only add new things, but also omit certain things, reshape, amplify, reestablish certain meaning. So there are many ways in which the Constitution can be altered. And also there's no limit in the content of what can be changed in the Constitution. The only limit is on the mode of altering it. And this formal requirement, this way in which the Constitution can be altered, is called manner and form. So section 128 establishes the manner and form according to which the Constitution can be changed, but it does not say anything about the content of the change that the Constitution is about to suffer. This is relevant because there are certain constitutions around the world that do not admit certain types of amendments. There are certain constitutions whose parts cannot be altered. In Germany, for example, there are the eternity clauses. These are provisions that will remain the same during the whole reign of the constitution. The Brazilian constitution has a similar provision as well. They are called the stone clauses. These provisions in the Brazilian constitution cannot be changed in a way that will curtail the existence. But the Australian constitution doesn't have that. Everything that is part of the Australian constitution can be changed. There are no limits to the content of the amendment as long as the process is followed. Hey, is the preamble to the Australian Constitution part of the Constitution? Can the covering clauses of the Australian Constitution Act be changed? I have expressed my opinion about that in the video that I did about the preamble. You can check it by clicking on the top right corner. This Constitution shall not be altered except in the following manner. That's another thing that kind of follows what I've already said. Constitutions should change. It's good for them to change. But they shouldn't change without due consideration by those who will be affected by that change. As Quick and Guerin, those two commentators of the Australian Constitution, have said, a constitution is a charter of government. It is a deed of trust containing covenants between the sovereign community and its individual units. These covenants should not be lightly or inconsiderably altered. But as they continued, they also said, a constitution which did not contain provision for its amendment with the development, growth and expansion of the community which it is intended to govern would be a most inadequate and imperfect deed of partnership. Ultimately, this section, as Quick and Guerin called it, is a safety valve. It prevents from anyone to try to disturb the Commonwealth and its operation in Australia. Section 128 continues. The proposed law for the alteration thereof must be passed by an absolute majority of each house of the Parliament. So that's the first procedural step. Each house of Parliament has to approve the proposed law to amend the Constitution. And they have to do it by an absolute majority. What is that? An absolute majority is the majority of the whole of the seats in a chamber. It's different from a simple majority. Let me explain it to you. In a simple majority, we count the votes only of those who voted, who participated. Let's imagine here that you and I are part of a certain society and we have a group of 20 people part of that society. We have to take a vote, but there are only 10 people present. How many votes do I have to secure a simple majority? I'll have a simple majority by having 6 votes, because the simple majority counts the people that are present and are participating in the voting. So I only need 50% plus 1 of those who voted. That's out of 10, I just need 6. But for an absolute majority, I would need 50% plus 1 of the votes of everyone in our society. That is, I would need 11 votes. Let me give you an even better example. The Australian Senate has 76 senators. Each state has 12 senators, and the ACT and the Northern Territory have 2 senators each. I've talked about that in the video that I did about the differences between the Australian states and the Australian territories. You should check it out. So, in the Senate, an absolute majority would be 50% plus 1 of the 76 senators. 76 divided by 2 is 38, plus 1, 39. So I would need 39 votes to have an absolute majority in the Senate. Even if only 40 senators were there, it doesn't matter. I would have to secure 39 votes to make sure that my proposed amendment to the Constitution would pass. And according to section 128 of the Australian Constitution, that absolute majority is a requirement not only for the Senate, but also for the House of Representatives. Moving forward with section 128. The proposed law for the alteration thereof must be passed by an absolute majority of each House of Parliament, and not less than 2 nor more than 6 months after its passage through both houses. The proposed law shall be submitted in each state and territory to the electors qualified to vote for the election of members of the House of Representatives. Basically, what this part of the section is saying is that there is a certain time frame for the law to be approved and passed by both houses of parliament and then be submitted to the whole of the electorate. The proposed amendment needs to be submitted to the people somewhere between the 2 months and 6 months after its passage on both houses of parliament. This gives time for the provision to be presented before the people, so that the people can actually have an informed decision. In fact, no later than 14 days before the voting day, a pamphlet will be sent out and distributed among the electorate containing arguments for and against the proposal, so that people can really know what they are voting for. But what happens if only one of the houses passes the law and the other doesn't agree to it? What happens if the requirement of the absolute majority is only reached in one of the houses? Section 128 gives us the answer. Let's see. If either house passes any such proposed law by an absolute majority, and the other house rejects or fails to pass it, or passes it with any amendment to which the first mentioned house will not agree, and if after an interval of 3 months from the first mentioned house, in the same or the next session again passes the proposed law by an absolute majority, with or without any amendment which has been made or agreed to by the other house, and such other house rejects or fails to pass it or passes it with any amendment to which the first mentioned house will not agree, the Governor General may submit the proposed law as last proposed by the first mentioned house, and either with or without any amendment subsequently agreed to by both houses, to the electors in each state and territory qualified to vote for the election of the House of Representatives. I'll explain it to you. What the Constitution is saying is that if the houses can't agree, the Governor General will interfere. So there is even the possibility of the Governor General submitting the proposed law for amending the Constitution without the approval of both houses. The process that we just read is basically this. There is an amendment proposed by an absolute majority in one of the houses that is not agreed to by the other house. Then there will be an interval of 3 months. Afterwards, the amendment will be again proposed by that same first house, and again it could be rejected by the other house. If that happens, then the Governor General may submit the proposed amendment to the electors in each of states. Okay, so what happens next? If either the proposed law is approved by both houses of parliament through an absolute majority, or if the Governor General decides to submit it to the electorate nonetheless, the next step is a vote. When a proposed law is submitted to the electors, the vote shall be taken in such a manner as Parliament prescribes. And then, if in a majority of the states, a majority of the electors voting approve the proposed law, and if a majority of all the electors voting also approve the proposed law, it shall be presented to the Governor General for the Queen's assent. This is called the double majority. Do you see that the electors' vote will be counted twice? In one, we're counting the majority of electors in a majority of states. In the other, we're counting the majority of all electors in all of Australia. Do you also see that there's a federal element there? The framers of the Australian Constitution wanted to make sure that the Constitution would only be altered if the majority of the people of the states agreed to it, as well as the majority of the people of the whole Australia. And one of the main reasons for it is because this prevents the more populous states from trampling the interests of the smaller states. So this is another aspect that we can highlight as an important feature of the federal system in Australia, and how relevant the federal principle is and still is here today. So in the first place, more than half of the electors of all of Australia must vote yes. In the second place, separate majorities in more than half of the states must vote yes. If the proposed law doesn't secure this double majority, then the amendment fails. Section 128 then says that if the double majority is reached, then the proposed law will be presented before the Governor General for the Queen's assent. When I have a video just about the proceedings in Parliament, I will talk about the Queen's assent, the royal assent. But for now, what I want you to know is just that this is a formality that closes this process for amending the Constitution. It's a necessary step for the proposed law to now become law. And unless the amendment expresses a contrary intention, the proposed amendment will take effect on the same day as the royal assent. So, with the royal assent, the amendment comes into operation and the Constitution is formally altered. Well, thank you for watching this video until the end. Don't forget to like it, to subscribe to our channel and hit the bell sign. I hope to see you next time very soon. Until then, ciao!